But, you know, hours after that High Court judgment, and Owerri High Court issued a counter order, and the State High Court granted an order of interim injunction restraining INEC from recognizing Senator Ararume as Imo North senatorial candidate of the All Progressives Congress, or issue him certificate of return or any other instrument in his favor, and they say in respect of the said election, pending determination and hearing of the motion on notice in that case. This followed an application by a motion expert, actually, which was brought to it by All Progressives Grand Alliance. That's one Mr. Kelechi Soribe, a member of the Imo State Working Committee of ABGA, and 5 others against Senator Ararume, INEC, and the APC. So that happens to be the bone of contention. But now we're going to hear a lot more as we progress. Mark, do you want to introduce those guests?
Indeed, Chamberlain, thank you. We have with us Mr. Tunde Falola, who's the man you saw earlier. He's the counsel to the plaintiffs, counsel to Mr. Ararume, and he's with us now at Abuja Studios. We also have with us Mr. Oseloka Zikora, who's the spokesperson of the Frank Ibizim campaign organization. Gentlemen, you're welcome to Sunrise Daily this morning.
Thank you, Mobe, for having us.
Thank you very much for having me around.
So you spoke immediately after the court gave the judgment yesterday, and you seemed rather happy with the judgment. But right now, I don't know if has your victory been cut short by this ex parte motion coming from Owerri?
Thank you very much for having me around, and good morning, Nigerians. Indeed, you were happy yesterday, and up to now we are still happy, because in the face of the law, there's really nothing to worry about. The judgment that was delivered by Federal High Court yesterday, per Honorable Justice Taiwo, was a judgment, that dealt with, issues canvassed by, parties. It was a judgment that determined the right of the parties. It was a judgment, that took into cognizance the hearing, argument, and what have you. So it is a final judgment as far as the jurisdiction of that court is concerned. And unless and until that judgment is set aside, there's nothing to worry about. The judgment, the ruling you are talking about, we are not aware. We just read it, the media, and, we are surprised that that kind of order was made. Because in the first place, no court of concurrent jurisdiction has, the jurisdiction to set aside or sit on an appeal of a judgment, of a court of equal jurisdiction. In other words, Federal Court and High Court of a state, as it were, in this case, Federal Court in Owerri has no that jurisdiction, but under the law, the Constitution, to set aside the judgment delivered by Federal Court here in Abuja. The reason being that, in our whole matter, the court took evidence, both documentary and what have you. We made submission, we addressed the court. So it was a judgment, that was conclusive.
Is that what this expert motion has done? Has it set it aside, or is just telling INEC, do not recognize this person yet until this is sorted out?
The order was made without jurisdiction. INEC is a federal government agency. It is only Federal High Court that has power to compel or issue order against INEC. You can't go to a state court, a state high court, and have to another against a federal agency. Authority has settled on this, so there is no no cause to worry about. And INEC, I have to tell you, is not bound to obey that court order. I say this because the order was made, without by concealing facts. Because if His Lordship, if he has taken into consideration all the facts and the antecedent of this case, he wouldn't have given that kind of order. So is it that the court was misinformed, or the applicant that went there, deliberately, conceal facts, from that court. So ordinarily, this is a matter that started in December. The Imo North senatorial election, took place in December. So the question we had to ourselves is, where was ABGA between December and March this year? Where were they? Are they going to tell Nigerians that they are not aware of the pendency of a suit at the Federal High Court? Are they going to tell Nigeria that they are not aware that nobody has been issued certificate of return until yesterday when the court order. So where were they when we filed this suit, when other parties, were in court?
So you have no fears that INEC could recognize that particular judgment?
No, it's not possible. It's not possible. It's elementary. It's elementary.
Okay.
It's elementary. A court of coordinate jurisdiction has no power to set aside, because by implication, what you are saying is that INEC should not obey, a valid and subsisting order of a federal court, when indeed they are not a court of appeal by virtue of the provision of Section 41 of the 1989 Constitution. It's only court of appeal that can set aside that decision, because it was a final decision, and it determined, the right of the parties before the court.
Let me come to you, Mr. Zikora.
Yes.
Your candidate seems to be holding the short end of the stick right now within the ranks of the APC. How are you taking this? Do you intend to appeal?
We have already filed a notice of appeal on the motion for stay of execution of the judgment of Justice Taiwo. And let me state here that we find that judgment very strange. We find it strange in the sense that we don't even know what that suit should be called within the realm to categorize that suit. Was it a pre-election matter or a post-election matter? I ask this because every other action that is taken before an election forms a pre-election matter. The issue that my good friend that canvassed in the court is supposed to be a pre-election matter. And the action that they were not happy with was the action of submitting the name of Chukwuma Francis Ibezim to INEC as the validly nominated candidate of the APC. That nomination was done and submitted to INEC on 13th September 2020. By virtue of the law, if you have any grounds concerning that, you should file an action in the court within 14 days to set aside whatever has been done by the party. The current judgment that we're talking, suit that they gave judgment on yesterday, was not filed within 14 days. It was filed after the election of December 5th, 2020. Now, if it was filed after the election of December 5th, 2020, what is it then? Is it a post-election matter? If it is a post-election matter, the Electoral Act clearly states that all post-election matters shall be treated by a competent tribunal or court. And the competent tribunal or court, it says that competent tribunal shall be, in the case of the presidential election, the Court of Appeal. In the case of all other elections, it should be the tribunal. There is a tribunal that has already been set up concerning the election of the Imo North senatorial by-election. And he knows that they are also in that tribunal. So we don't really understand what informed the judgment of the Honorable Justice Taiwo. But
you were parties in the suit.
Yeah, we argued these matters. We argued these matters, and yesterday he mentioned the fact that he's not aware of any appeal concerning the disqualification of Sir Francis Ibezim by a federal high court in Abuja, that he's not aware of any appeal. Yet in the same breath before he mentioned that, he discountenanced the motion which sought to stop the judgment because we considered the suit an abuse of court process, because the plaintiff was seeking the same reliefs at the Supreme Court by way of a cross appeal. He discountenanced that by the fact that the plaintiff argued that he has withdrawn the cross appeal at the Supreme Court. He ruled against that motion. Now he goes ahead to say that he's not aware of any appeal. What was the cross appeal for? The cross appeal was done concerning an already existing appeal by Sir Frank Ibezim, which is already underway at the Supreme Court. The Supreme Court has fixed a day for hearing on the 23rd of March, that is next week. So we thought that Justice Taiwo should have exercised discretion to have at least waited for the Supreme Court to have ruled on the issue of disqualification, which is his main key of arriving at the decision that Sir Frank Ibezim is not the candidate of the APC. And by the way, the major problem with this is that the issue of the candidature for APC has already been settled. It has already been settled.
By who?
By both the Court of Appeal and the Supreme Court.
I think you have to
let me finish this point. Let me finish this point.
You'll have your time.
The Court of Appeal, Senator Godwin Ararume got a judgment of the Federal High Court, Owerri, to replace the name, directing INEC to replace the name of Sir Francis Ibezim as the candidate of the APC for the by-election with his name. When he got that consequential order, it was appealed against. And the Court of Appeal set aside that judgment of the Federal High Court. When the Court of Appeal set aside that judgment of the Federal High Court, that means that the consequential order that he received, which made him a candidate for a few days, is no longer in place. It was as if it never happened. So by material fact, that means that the candidate of the APC, from the time his name was submitted to INEC on 13 September till the election date, was Sir Francis Ibezim. That same judgment of the Court of Appeal that sat in Owerri was appealed against at the Supreme Court by Senator Ararume. And the Supreme Court ruled on 5th of February this year, upholding the judgment of the Court of Appeal, invocating, dismissing, setting aside the judgment of the High Court that replaced Ibezim's name. That clearly finalizes the issue of who the candidate of the APC is.
Well,
the APC candidate for the election is Sir Francis Ibezim. As to the issue of ongoing litigation...
No, let him quickly respond to this one.
Thank you. First and foremost, I'm surprised the way my friend is addressing Nigerians, because it seems most of his submission tends to mislead the public. I said this because he's not a lawyer.
Well, that's why you're here. So
yeah, he's not a lawyer. I'm surprised why their lawyer is not here. Their lawyers, let me trace the history of the case. As at the time, our client, Senator Ifeanyi, that has been declared the winner of that election, went to the poll. There were two judgments. We have judgment of the Federal Court, Owerri Judicial Division, and we have judgment of the Federal Court, Abuja Judicial Division. Owerri Federal Court decision.
They are courts of coordinate jurisdiction.
Yes, on different parties and on different issues. Now, Owerri, Federal Court Owerri, ordered or declared that the participation of their client, that is a Frank Ibezim, at that primary, was a nullity because they had been disqualified ab initio. So that issue went to Court of Appeal. So when Court of Appeal took that decision, the Court of Appeal held that this same Frank Ibezim that the lower court said, did not participate, legally, he didn't participate legally at the primary. He was not joined as a party in that suit. So on that basis, the Court of Appeal nullified the decision of the Federal Court. The same matter went to Supreme Court, and what the Supreme Court did was to affirm the decision of the Court of Appeal Owerri Judicial Division. So in that case, the issue of the status of our client was never, an issue. I'm coming.
Excuse me.
So I'm coming.
You are
At that
misleading.
decision,
Hold on.
Bring out.
You are a lawyer.
Let him bring out the judgment.
You are a lawyer. Excuse me. You are a
Hold
lawyer.
on, gentlemen. Let him quickly clarify.
Let me clarify.
You are a lawyer, so don't mislead the public.
Hold on. When you are talking,
You actually
I
just
didn't
interrupted me.
So that decision, even up to the Supreme Court, there was no any pronouncement by the Supreme Court that our client, was not qualified or that he was not the candidate of the APC.
So what judgment came out of the Supreme Court?
The Supreme Court judgment just affirmed the decision of the Court of Appeal to the extent that the lower court cannot make an order against a party who is not joined in the proceeding. So the Supreme Court affirmed the decision of Court of Appeal that set aside that decision. That was number one. Number two, the judgment of Honorable Justice Echo of the Federal High Court, Abuja here, disqualified their candidate that he presented forged documents to INEC. He's here. Let him defend it. So that decision was also affirmed by the Court of Appeal. The Court of Appeal affirmed that, look, France, Ebezin, France, they are not, one and the same thing. So the Court of Appeal affirmed the disqualification of their candidate. So, and up to today, he remained disqualified.
But he raised the fundamental question. Hold on, let me quickly bring the question to light. As to whether or not this is a pre-election matter.
I'm coming to that.
Please quickly address it.
Now, on that issue, as a lawyer, I won't sit here and be discussing a matter, that is, that's been finally decided. They have lawyers at that court. Their position, is contrary to what he's saying. Now he's saying that the matter was not filed within 14 days, so it was neither pre-election matter or whatever. That was not their position. Their position at that court was that, number one, that it is their candidate that ought to have been declared because he was the one that participated. In any event, the issue of jurisdiction, which he has raised now, it is of no moment. Because our own case before the court is that having participated at that Imo North Central election, and INEC haven't declared the political party that sponsor our client, the Independent National Electoral Commission ought to have issued the certificate of return because I haven't declared the party as the winner, and I participated. He participated throughout.
How did he participate? The right question to ask.
I'm coming.
The right question to ask.
The position of the law is that.
Let him learn.
The position of the law is that if I have a right as a citizen, there should be means, of enforcing that right, and that is why we went to court. Court compelled these people, Independent National Electoral Commission, to declare our candidate because having participated, having won that election, and INEC haven't declared the party as the winner of the election. There is no reason why our client should not be.
I'm wondering though, was your candidate's name submitted to
INEC
at any point in time?
Yeah, it was submitted.
Okay.
It was submitted.
But it was taken off.
I'm coming.
By an order.
Was the name submitted or not? Let him tell Nigerians.
Okay.
What about order? Was the name submitted?
Was the name submitted?
Yes.
Okay.
Let me clarify this.
No,
the name that was submitted to INEC on 13th September 2020 for the by-election is the name of Sir Francis Ibezim. A Federal High Court in Owerri gave a consequential order to replace his name with that of Senator Ararume, which was done. But the Court of Appeal set aside that judgment. Now, my question to him as a lawyer is that if a Court of Appeal sets aside a judgment, is it set aside in part or in whole? The judgment of the High Court was set aside, completely nullifying the issue of that replacement ab initio. That means it is assumed that the implication of this is that since APC submitted the name of Sir Francis Ibezim on 13 September till the election was held, the APC candidate was Sir Francis Ibezim, not Senator Ifeanyi Ararume. Okay. So the issue there, I want to...
Gentlemen, I'm sorry, let's quickly...
Let me ask him a question, please. Let him tell us part of the judgment of that Court of Appeal and Supreme Court that says...
Let's quickly take this to Lagos now. Gentlemen, Chamberlain.
Oh yeah, Mr. Falola, did hear you say initially that the Owerri court cannot give this judgment that they've given because it's on the same matter. But at the same time, you also did say that some other cases can be given if they are different cases. But we also understand that what was the crux of the matter in Owerri is because they are arguing that Senator Arume did not resign his membership on the board of APGA, and that is what this case is about. So there are two separate matters which was filed by APGA. So isn't that a judgment? Isn't that judgment the right decision since there are two separate matters from the court in Owerri?
Thank you very much, Mr. Chamberlain. Let me make this one clear. I'm not abreast of the fact of the case at Owerri. I just read it in the media, just like you have explained now. But the point we are making here is this. Assuming without considering that actually the man did not resign his membership. And, as a judge, of court of coordinate jurisdiction, can that court make a valid order that will seem to set aside a decision, a final decision of a competent court of jurisdiction? The answer is no. What we are saying is this. A judge of a high court cannot set aside a decision, final decision for that matter, of another high court. Because federal court and high court of a state, they are both a high court. Now they are court of coordinate jurisdiction. What we expect, or what one would have expected them to do, if they are not satisfied by the decision of Honorable Justice Taiwo delivered yesterday, is to file an appeal by virtue of the provision of Section 241 of the 1989 Constitution, not to go and do forum shopping. Because even as Nigerians, we ask ourselves, how come that within less than 24 hours, when the federal court deliver a final decision, we have another counter but Mr. Falola,
how come
just a minute.
Let me put this in.
We are trying
hang on a minute, Mr. Falola.
To ridicule the judiciary.
Yeah, but just hold on.
Not going to be a
if
party
the
to
case
that.
has
And we're
been
also urging INEC.
Just a minute. If the case had already been ongoing,
fall into that trap.
I hope you can hear me, Mr. Falola. Just hold on. Now, if this case has been ongoing and then they're about to deliver a judgment, and which they did yesterday, are you saying that they should have disregarded all the previous processes because a judgment had been given somewhere else on a separate matter entirely?
No, the point is this. As you've rightly observed, it was an interim order. The question is, when did they file the matter? When did they file the matter? And when was their own action filed? We started this case in December last year. How come APGA or whoever that went to court, they did not consider it necessary to come and join in our own suit? When was the matter filed? And when a court gives an interim order, it presupposes that hearing has not commenced. It's a new suit. Interim order, please stop this party, temporarily. So it is a temporary order, unlike our own matter. Our own matter is a final decision of a competent court of jurisdiction, and it is only an appellate court that can set aside, that decision. We have practices in the past where we have counter order. The court of coordinate jurisdiction. One will make order today. Tomorrow we have another counter order. This is exactly what is happening in Nigeria now. And as lawyers and as legal practitioners, we are not going to be party to abuse of the process of the honorable courts. What I mean by that is that you can't be doing forum shopping. Today you went to you go to Asaba. Tomorrow you go to Lagos to obtain order over a similar matter. So the issue you should ask them is that when was the matter filed? This matter where interim injunction was obtained, when was the matter filed?
All right, we'll get Mr. Zikora to respond when we return in a moment. Don't go away. Welcome back. Mr. Zikora, go ahead and respond, please.
Yes. While we are not abreast with the details of the case at Federal High Court Owerri, but permit me to say that the issue of forum shopping that my friend is talking about seems to be what he has been doing, because he went to the Supreme Court on a cross appeal to seek the same reliefs that he suddenly found maybe he could get quicker at the Federal High Court, Abuja. So he withdraws the cross appeal that he had filed at the Supreme Court and goes to get a judgment at the Federal High Court, Abuja. And this is despite the fact that the basis upon which that judgment is given, which is that Ibezim was disqualified, is currently pending at the Supreme Court on an appeal. And I'll read you what the Supreme Court says about such matters. It says that even though the subsistence of appeal against the decision of a lower court per se will not operate as a stay of execution, it may amount to contempt of the appeal court for the lower court to proceed with enforcement of its judgment during the subsistence of the appeal, the fact of which the lower court is seized of. So what does that say? Since Justice Taiwo is aware that there is a pending appeal concerning this matter of disqualification of Sir Francis Ibezim by a Federal High Court in Abuja, that it amounts to contempt of the Supreme Court to go ahead to give a judgment and direct INEC to issue a certificate of return to Senator Ararume within 72 hours. That is very strange. That is really very strange. And per se, too, to note that we've already filed a motion of stay of execution and a notice of appeal against that judgment. Right. And meanwhile, these issues will, of course, be finalized by the Supreme Court once the Supreme Court finishes its proceedings on the appeal that has been brought by my principal, that's Sir Francis Ibezim.
Well, Mr. Zikora, there's a question that I think we've not answered, or you have not answered, and that's concerning the ex parte motion at the Owerri Court yesterday. When was it filed? When was the matter filed?
I will not know because I'm not a member of OBGA, but you will note that what OBGA is looking for, that's what OBGA is filed, are issues that are not connected with the Federal High Court ruling in Abuja. And I'm sure that as at the time that this case, even the Federal High Court judgment had not been given. So they are there on their own to settle scores with Senator Ifeanyi Ararume. So the order has been given, though interim it is an order, and INEC is bound to obey it until it is set aside, however foolish that anyone may think the order is.
But clearly, your candidate is a beneficiary of that motion, and you're gracefully latching onto it.
Gratefully latching onto it? We don't need to. We don't need to, actually, because why we don't need to is, even though that order has been given to INEC, by virtue of the fact that we have put a notice of appeal and a motion of a stay of execution, by what I have told you that the Supreme Court's opinion is, that INEC would not be in a position per se to issue any certificate of return to Senator Francis, to Senator Ararume.
I don't quite get that part, because clearly a Federal High Court just asked INEC to give him a certificate of return in 72 hours. So is there another conflicting judgment against that?
Conflicting judgment. The conflicting judgment is that there is an interim order from the Owerri High Court on a separate matter, which also restrains INEC from granting any recognition to Senator Ararume as the winner of the Imo North by-election.
Well, Mr. Zikora, yet again, you're saying you just said you don't need to latch onto that, but I mean that's what you're quoting now. But I know that Mr. Falola wants to respond to some of the issues that have been raised. Mr. Falola, please go ahead.
Thank you very much. Let me correct an impression here. Like I said, I did say, at the outset of this interview, it is unfortunate that their lawyer is not here. Most of this issue is canvassing here had been dealt with by the court. The issue of pendency of an appeal and the judgment of the Supreme Court, came on board during the trial, and the court ordered all parties to come and address it on the propriety or otherwise of the judgment of the Supreme Court, first appeals, the judgment just delivered yesterday, the court took our argument, including their own counsel. All of us were in court. We addressed the courts on the propriety or otherwise of whether a subsisting appeal or on the decision already delivered by the Supreme Court. And the court, having duly considered those arguments, came to a conclusion that the pending appeal at the Supreme Court, or court of appeal as it were, or the decision already delivered by the Supreme Court has nothing to do, in respect of this case. And he went ahead and delivered the judgment. So I'm surprised that he has to come here and be addressing Nigerians on issues that that was duly confirmed by their lawyer before the court. That's number one. I'm coming. Please don't interrupt me. Now he's talking about interim order, and he knows. Let me presume that he knows that an interim order, at times it lapses, depending on the rules of court, it lapses for just 14 days. It's an interim order. In our own case, we have a final judgment of a court of competent jurisdiction. The court, it took all the arguments of parties, it took the addresses of the parties, and came to, a logical conclusion that our client, he is the rightful person that ought to be issued that certificate of return. If anybody is not pleased by this judgment, for heaven's sake, the best option for them is to appeal. Go to court of appeal.
Mr. Falola, just one last thing.
The judgment.
Just one last thing from me here. All of these circumstances has pretty much put INEC in a very, very difficult position, and it will seem the entire political landscape, so to speak, because the Constitution, the Electoral Act, does not recognize a situation where INEC declares a party without a candidate. Now, you are a lawyer, and speak to us from the point of law. How significant a confusion has this situation created?
Thank you very much. Let me say clearly that there is no confusion here, because if you look at the interim order they are parading around, the question you have to say was that order made, by a court, or the court, has jurisdiction to have made that order in the first place? How can you make an order against a federal government agency? INEC, for goodness sake, is a federal government agency. It's only federal high court that can make a valid order against INEC. You can't go to state high court, and ask, for an order. They know what they are doing. How come did they go to Owerri when a judgment was delivered, in Abuja just yesterday, within 24 hours? Where was the matter filed? That's the question you should tell us. Because they want to leverage on that interim order and continue to, misinform Nigeria that, INEC has to be. INEC cannot comply with that kind of order, because INEC too, they have a legal department, and they will be appropriately advised.
I could respond to this. I think that basically that part of this issue, part of the confusion that we have, is that INEC actually did not ab initio issue certificate of return to Sir Francis Ibezin, being the validly nominated candidate of the APC in that election. The issue of disqualification, which INEC based that there are several court orders and what have you, is tried in law. And I have said, I've already quoted that once a matter is on appeal, you cannot continue to implement any decision, that's execute any decision that was made by a lower court. And let me again read what the appeal court said about this. It says it is true and correct to observe that the notice of appeal filed will not operate as a stay of execution. And Section 24 of the Supreme Court Act makes this more clear. But it is equally correct to point out that the section does not prescribe in favor of any execution being carried out during the pendency of an appeal. So for INEC to have wasted time, continue wasting time to have issued the certificate of return to South Francis Basin is what is causing this problem. And as far as I am concerned...
right now, the judgment that has been obtained by Senator Ararume is, stipulates a time frame within which it has to be issued a certificate of return.
However, there is also valid law to say that judgment, that INEC is not obliged to obey that judgment. Because there is a pending Supreme Court appeal. And the law states quite clear that you cannot execute a judgment
I think you've made
when there is an appeal going on.
I'm coming.
You made
As at today,
there
is no appeal against the judgment of Federal Court delivered yesterday. So INEC is bound, to obey that law. The judgment. The judgment is a judgment in rem. A judgment is a judgment that defines the status of parties.
There is an appeal. There's a notice of appeal.
I'm coming. That judgment, it is binding on every authority, including INEC. It's a judgment in rem.
There is a notice of appeal.
The whole war.
There is a notice of appeal.
There is not notice. We are not aware.
There is a notice of appeal which has been served.
From what he has just quoted, does the notice of appeal, assuming without considering that it's a notice of appeal, does it operate as a stay? The answer is no. As of today,
but it says,
the judgment was delivered yesterday.
It says
there is no notice of appeal against that decision of Honorable Justice Taiwo.
It says
gentlemen, we have to leave this conversation.
This does not prescribe in favor of any execution being carried out during the pendency of an appeal.
We have to leave this here, but it's obvious that we haven't heard the last on this particular matter. So let us see how things eventually pan out. But we have to thank you both for coming on Sunrise Elite this morning. Mr. Tunde Falola.
Thank you very much.
Is counsel to Senator Ararume, and Mr. Oseloka Zikora is spokesperson of the Sir Frank Imizim Campaign Organization. Gentlemen, thank you for coming to us this morning. Well, Sunrise Elite continues in a moment. Please stay with us.